I call this meeting to order. So welcome to meeting number 72 of the House of Commons Standing Committee on Public Safety and National Security. We will start by acknowledging that we are meeting on the traditional unceded territory of the Algonquin people. Today's meeting is taking place in a hybrid format pursuant to the House Order of June 23, 2022, and therefore members are attending in person in the room and remotely using the Zoom application. Pursuant to the order of reference of Friday, November 25th, 2022, the committee continues consideration of Bill C-20, an act establishing the Public Complaints and Review Commission and amending certain acts and statutory instruments. Before we get started, I'd like to advise the committee members that we need to approve a budget for this study. I think everyone received a copy of the budget in your email yesterday, and I wonder if we can get a motion to approve this budget. Are we all agreed on approving this budget? Okay, absolutely. Carried. There you go. Okay. I would also note to the committee members that today is our last witness meeting. On Friday, we had tried to schedule estimates, but the minister is not available, so my thinking is that we will cancel that meeting, and we will be able to get up to speed on all the amendments that are coming.
It is.
It's up to the committee. Are we all okay to cancel that meeting? Ms. Stancho.
Thank you, Mr. Chair. So just so I'm clear, we will not be getting the minister for estimates?
That's correct.
Okay. Is that that's a bit abnormal, right? Or
well, we invite,
yeah. Okay.
And it's really up to them to accept or not. We haven't had that many opportunities to do so, but.
I mean, Mr. Chair, I'm concerned about accountability. It's a big budget, lots in there. Just voicing my concern and disappointment that he was not able to come on Friday. It is important that this committee question him on his very large budget with billions of taxpayer dollars. So it is disappointing, but I appreciate that you tried, Mr. Chair.
Yeah. Okay. Thank you. That all having been said, we have quite a number of amendments have come in. We should get the bulk of them by deadline or close of business, let's say today, and they will be able to be put into a package. We're not exactly sure, but maybe by Thursday or Friday we might see that package. Other amendments may come in over the course of time. If they're few and far between, we can probably easily incorporate them into the package. But of course, we're all able to submit amendments from the floor when the time comes. In any event, that all having been said, welcome to our witnesses. Thank you. Today we have two panels of witnesses.
Point of order.
Sorry, go ahead, Mr. Julian.
Thank you, Mr. Chair. I just wanted to, we had spoken about having an extended meeting next Tuesday, and I just wanted to make sure that everything is in place for that.
Yes, I've asked the clerk to scrounge and see what we can find. At the moment, the terrain is a little bit uncertain for next week. We don't know which committees are meeting, which aren't. We have certainly asked for more time for Tuesday and possibly Monday afternoon and maybe even Wednesday. My thinking is the longer we wait in the week, the less likely we're going to have a House sitting. So we're doing what we can to get more time. So, all right. I'm sorry?
Looks like we will not be sitting on Friday.
We will not be sitting on Friday. So, yeah. Okay. So we have two panels of witnesses. Firstly, let us welcome today in person from Faces of Advocacy. We have Dr. Edward Oipoon, founder, John McCall, member. We have from the National Council of Canadian Muslims, we have Fatima Abdallah, communications coordinator, and Nadia Hassan, chief operating officer. And with us by teleconference, we have from the National Family and Survivors Circle, Hilda Anderson-Piers, chair. So welcome, everyone. We will start by inviting Mr. Poon to make an opening statement of up to 5 minutes.
Hello. My name is Dr. David Edward Uwe Poon. Please call me David.
I'm the founder of Faces of Advocacy, a grassroots Canadian organization that was responsible for federal immigration policy changes for the safe reunification of multinational families during the COVID-19 pandemic-related travel restrictions. I have the sincerest gratitude for many parliamentarians, including many here today, who helped bring together Canadian families in a responsible way by listening to the experience and pain of so many firsthand. I hope we can do that again today. I want to begin by telling you why I founded Faces of Advocacy. Early in the pandemic, the government completely ignored multinational Canadian families who had partners, children, or parents of different citizenships. The rules at the time were vague enough, however, that it could be interpreted that the international family members of Canadian citizens could come into Canada, and there were multiple reports of CBSA agents allowing that. My partner is an Irish national. She had contacted the CBSA, the IRCC, and the embassy, even receiving a letter from the consulate in Europe attesting to our relationship status. She was told she could come to Canada. Upon landing in Toronto, the CBSA agent did not allow her to enter, outright lying to her that there was no way to speak to a supervisor, denying her the time to read any forms before she was forced to sign them, and being intimidated by being called a liar. That same agent later admitted to her that day that he knew she was not a liar, but still used these aggressive intimidation tactics alongside outright falsehoods. We later submitted an ATIP on the interaction where the CBSA agent did not record his unprofessional behavior nor the misinformation he presented my partner with. He faces no consequences. Members of the committee, I am the face of a national organization of over 10,000 people who caused the government to change federal policy. Whenever I enter the country with my partner, I am still scared. Imagine this was a person without a platform, just wanting to be with their family. John McCall is such a person. He is an American citizen who fell in love and married a Canadian woman, Donna, 40 years ago. While their children have a right to Canadian citizenship, they were Americans in the eyes of the CBSA. When Donna became ill early in the pandemic, the McCall children pleaded with the CBSA for a compassionate exemption to allow them to be with their mother before she passed. They were given a form letter response that a Canadian passport was needed. We know that different CBSA agents at the time interpreted the pandemic-related border restrictions to allow family reunification. But with unclear rules and CBSA agents unwilling to help the McCall family find a solution or even escalate to someone who could, the McCall children said goodbye to their mother over FaceTime. John and I connected, we worked with Faces of Advocacy, we changed federal policy with public safety's help much later. However, despite these seeming victories, there were those who were still denied entry into Canada or treated like liars, despite well-documented compliance with entry exemption requirements simply due to the whims or unwillingness to listen by individual CBSA agents. Immigrants quickly learned they had no recourse to challenge the decisions made by CBSA agents under the authority or discretion afforded to them without oversight. It is for those reasons that Faces of Advocacy is pleased to support Bill C-20, which seeks to level the imbalance of power between the complainants and the CBSA. We are in strong support of the proposed empowerment of the Public Complaints and Review Commission to impose disciplinary measures upon the CBSA and the requirement for the Commission to produce an annual report that must include disaggregated race-based data. There are 3 areas of C-20 we wish for the committee to refine. The first is Part 1, about the joint time limit service standards established between the Commission and the CBSA. The PCRC has been made necessary by the inability and at times outright obstruction of the CBSA to investigate good faith complaints. Our organization has heard many, many complaints from immigrants to Canada who have been told that there is no access to a CBSA agent supervisor and their decision is final, essentially threatening those who dare question the agent. We fear a requirement to, quote, jointly establish, end quote, service standards will be viewed by the CBSA as an opportunity to delay investigation and therefore delay justice. We ask that the committee replace the existing directives as they are written and actually develop reasonable service standards, particularly in urgent cases. Secondly, Part 1, Section 9 speaks to education and information about the Commission. We agree the need to have the Commission's existence and purpose to be well known. It is our belief, though, that the mandate and processes of the PCRC must be specifically and clearly promoted at key points of individual contact with the CBSA, and the onus must be placed on the CBSA to satisfy this promotion requirement.
I'm sorry,
All
sir,
public
could you wrap up?
Yes. All public CBSA stations should be required to post these rules. A CBSA agent cannot be allowed to outright misinform. And finally, the appointed members should have not only Indigenous representation, but those of international families as well.
Thank you. Well, I'll now invite Ms. Hassan and Ms. Abdallah to make your opening statement of up to 5 minutes.
Mr. Chair and members of the committee for providing us the opportunity to offer our thoughts on the study of this committee on Bill C-20. My name is Nadia Hassan, and I'm a PhD by training and the COO of the National Council of Canadian Muslims. I'm joined today by Fatima Abdallah, who I will be sharing time with, as a communications coordinator for the Council. I would also like to acknowledge the work of our summer students, Zaina and Hesna, who have significantly helped in the preparation of the submissions that we'll present before you today. At the outset, I just want to say that we at the National Council of Canadian Muslims have been advocating for many years for CBSA oversight legislation. NCCM has heard countless stories over the last 2 decades about the challenges that Muslims face at the border. That is why one of our key battles over the last 2 decades has been in calling for oversight over the Canada Border Service Agency. While we support the passage of this bill, we would like to see 3 key amendments, without which we have grave concerns that the impact of this bill will be very limited first step, rather than the kind of comprehensive reform we need to see now. Firstly, we suggest that the definition of national security in C-20 needs further clarification. We believe the current language of the bill means that there could be an unforeseen consequence arising from Section 31, subsection 2. As the bill is currently drafted, this clause suggests that all national security matters should be referred to the National Security and Intelligence Review Agency, or NCIRA. And let me give you an example. There's a well-publicized case around an Egyptian human rights activist, Abdulrahman Al-Mahdi, who was deemed a security threat by a CBSA officer in Vancouver, where he was also subjected to detention and was not given medical support that he needed. For example, they took away his hearing aids. If CBSA oversight legislation requires Mr. Al-Mahdi to still have to go to NCIRA, we know that it would take years until Abdulrahman receives a review of the alleged impugned conduct. More importantly, it would mean that for Mr. Al-Mahdi and for other Muslims who are allegedly unfairly targeted by CBSA agents for supposed, in quote-unquote, national security reasons, Bill C-20 does not help them at all get appropriate oversight and would simply add to the administrative burden NCIRA currently faces. We agree with other voices before you that the Commission should have jurisdiction to conduct reviews of activities that are in relation to national security in certain cases. We recommend, amongst other potential solutions, that an amendment to Section 31 be made to clarify that only complaints that require complex, top-secret clearance or documentation go to NCIRA, whilst all other complaints around national security complaints arising from alleged CBSA misconduct should be dealt with by the Commission. Secondly, we recommend that clear timelines are enshrined. As you have heard from a number of other colleagues, there should be strict timelines for the CBSA and the Commission to investigate and report on complaints. Secondly, on the same point regarding concern of delayed review, our concern is that without the installation of a set timeline in legislation, this new oversight body could take a lot of time to process and initiate reviews. We recommend an amendment to Section 8, subsection 1, that requires a timeline of 3 months for the oversight body to deal with the first step of a review process for the complaint, rather than leaving it to the Commission and the RCMP to establish the time limits. I'll turn it over to my colleague Fatima.
Finally, Although the bill identifies the need to protect against unreasonable searches and seizures, we recommend a zero tolerance for racial discrimination provision. We have seen a number of Muslim clients mistreated with Islamophobic or racist conduct by the CBSA, whose misconduct has historically gone unchecked. Recently, research conducted in March 2020 found that over 75% of CBSA officers surveyed said they witnessed a colleague discriminating against travelers based on their national or ethnic origin. To put it in clearer terms, we are aware that in one instance, a CBSA officer cited sources in a decision that drew on well-known Islamophobes like Daniel Pipes, and in one instance cited information that linked to hateful accusations leveled against NCCM and other prominent Canadian Muslim organizations. To the best of our knowledge, the CBSA has never publicly apologized for relying on such nonsense. As such, considering the history of the CBSA and the clear presence of Islamophobic prejudice in its work culture, a zero tolerance for hate clause should be instituted. Thank you. I also note in closing that we will expand significantly on the submissions before you today in a follow-up brief to be submitted. Subject to your questions, that concludes our submissions.
Thank you. I now invite Ms. Anderson-Pierce to make an opening statement up to 5 minutes. Please go ahead.
Thank you so much for the opportunity to present today. Good afternoon. My name is Hilda Anderson-Pierce. I'm the chair of the National Family and Survivor Circle, and I'm joining you today from Winnipeg, Manitoba, located in Treaty 1 territory in the traditional lands of the Anishinaabe, Innu, Anishinaabe, Dene, and Dakota, and the heart of the homeland of the Métis Nation. The National Family and Survivor Circle is comprised of Indigenous women and 2S LGBTQIA+ people individuals of diverse distinctions from across Canada who are family members who are directly impacted and survivors of gender-based violence. We utilize our lived experience, expertise, and self-determination as individual rights holders to advocate for ending gender-based violence against Indigenous women, girls, Two-Spirit, and gender-diverse people, and for the implementation of the 231 calls for justice. Bill C-20 and all subsequent federal legislation must be drafted, studied, adopted, implemented, and monitored with a view of its contribution to achieving the transformative changes this government promised in the federal pathway to addressing missing and murdered Indigenous women and girls and 2S LGBTQIA+ people. It is recognized that pursuant to Section 4.2 of the Department of Justice Act in June 21, 2022, the Minister of Justice tabled a charter statement regarding Bill C-20 to identify, examine legislation for inconsistency with the Charter of Rights and Freedoms. Today, I remind this committee that the 231 calls for justice are legal imperatives and arise from international and domestic human and Indigenous rights laws, including the Charter, the Constitution, and the honor of the Crown. As such, Canada has legal obligation to fully implement these calls for justice from the National Inquiry into Missing and Murdered Indigenous Women and Girls final report. Bill C-20 can be a step forward in fulfilling its legal obligations by aligning it with Call for Justice 5.7. This call is for federal and provincial governments to establish robust and well-funded Indigenous civilian police oversight bodies or branches within established reputable civilian oversight bodies within a jurisdiction, in all jurisdictions, which must include representation of Indigenous women, girls, and 2S LGBTQIA+ people, inclusive of diverse Indigenous cultural backgrounds, with the power to observe and oversee investigations in relation to police negligence or misconduct, including but not limited to rape and other sexual offenses, observe and oversee investigations of cases involving Indigenous peoples, publicly report on police progress in addressing findings and recommendations at least annually. While Bill C-20 replaces a civilian for a public complaints and review commission and expands to include Canada Border Services, the spirit of call for Justice 5.7 is the same. The legal imperative to establish a robust, well-funded, independent oversight body that is representative and inclusive involves accountability mechanisms and is transparent. In its contribution to the National Action Plan, the National Family and Survivor Circle identified Call for Justice 5.7 as an immediate action for implementation. Due to the limited time of this presentation, I will only highlight high-level concerns related to Bill C-20 in the areas of representativeness and inclusivity, trauma-informed approaches, and accountability mechanism. In 2021, Minister Lametti stated that we are confident that this federal pathway provides the needed principles and the foundation to build a fairer, stronger, and more inclusive and representative justice system that respects the rights of Indigenous peoples and protects Indigenous women, girls, and 2S LGBTQIA plus people. And we are committed to implementing new actions and policies that address those inequities. This is from the federal pathway to address missing and murdered Indigenous women and girls and 2S LGBTQIA plus people. When it comes to Bill C-20, Indigenous women and girls and 2S LGBTQIA plus people must be represented and included as decision makers and investigators. The Indigenous gender lens is a specialized skill and expertise that can only be obtained through lived experience involving daily navigation of and confrontation with systems that historically harmed us and continue to do so today. We possess critical insight into solutions for our safety, protection, and dignity that anyone else not in our situations or circumstances can fully know and therefore fully address. Section 33.3 indicates the complaints against the conduct of the RCMP officer or CBSA employee or must be made within 1 year after the day of which the conduct is alleged to have occurred. This could be extended by the commissioner or the commission or the commissioner, Section 33.4 of the commission or the president, Section 33.5, if either is of the opinion that there are good reasons for doing so and that it is not contrary to the public interest. The terms good reason and public interest are not defined in the bill and would place the onus on Indigenous women, girls, and 2S LGBTQIA plus people and other complainants to demonstrate they have good reasons.
Are you able to wrap up now?
Yes, and it's basically like we want to ensure that there's spaces for Indigenous women, girls, and 2S LGBTQIA plus people to be involved in this process with equity, quality, and decision-making, and to ensure that the 231 calls for justice are included in this process. I have more to say, but unfortunately, due to the time constraints, hopefully I can, share additional information through the questions that may be asked. So thank you for the opportunity. And this document was also shared. Thank you.
Thank you. And thank you all for your statements. We'll start our questions now. We'll start with Mr. Shipley. Mr. Shipley, go ahead, please. 6 minutes.
Thank you, Chair, and thank you to all of our witnesses being here today. Chair, if you'll indulge me, I just have a quick question for the clerk. If he could confirm Dr. David Edward, you want to go by David, but I'll struggle with that a little bit. He was invited by which group to be a witness, sir? Clerk?
I don't know who invited him.
I talked to the clerk before.
Mr. Clerk, if you wish to answer.
So it was submitted by the Liberals.
Thank you. And the reason I say that, I'm not doing it to be glib. I'm doing it so no one thinks I'm doing some type of a political attack job here. You weren't our witness. Sir, when we did a little research you've been involved in this case for quite some time and I commend you for all the work you've done out in the past. But back in 2021, you were so frustrated with the system that you actually decided to run against Minister Blair as an independent because he refused to meet with you for 18 months regarding border restrictions and CBSA oversight. Your exact quote from the Toronto Star was, "If it takes me running an entire campaign just to be able to speak to Bill Blair face to face, that shows how absurd the system is, that a person needs to run a federal election campaign just to speak to the man who needs to be accountable for those actions." I'd love to give you a little bit of time here to expand on that and tell me what the frustrations you must have obviously gone through, because I know how much it is to put your name out and run. So go ahead, sir.
Thank you. And if I can offer a little bit of my time, Bill, the people who have helped the exemptions, I'm so grateful. There are many in this room who did help us. but there were many who did not offer us the time that I thought was appropriate given the circumstances. Mr. McCall's wife, a nurse in Canada, died saying goodbye to her children through FaceTime from a system that did not care to give them more than a form letter. At the time, Minister Blair was the Minister of Public Safety and Emergency Preparedness. I ran that campaign asking him to just call John. That was 2021. We asked in 2020. Now it's 2023. So yes, it was absurd that I had to run as an independent, not partisan, just to get that attention and that discussion. And I once again bring John McCall driving all the way in from his retired wonderful life in Maddock just to get a little FaceTime and the small modicum of respect that a man deserves after suffering so much. His example allowed a family to reunite in Canada when her sister was dying because of the example that he and Donna put together. So yes, I do big things, but that's in honor, and we advocate for Donna, and that's why we're here today.
Well, thank you for that. Mr. McCall, would you like to add anything to that?
Only that.
Oh, you just turned them off. There you go.
There. Only that when I started this effort to try to get my children into Canada so they could be with us, my wife wasn't in imminent danger of death. She was needed a liver transplant there, and I started out by writing the Prime Minister and asking for some kind of exemption or some kind of consideration that might allow them to be with us together as a family before she got seriously ill and before she needed a transplant there, before the transplant process took place. Her condition just continued to deteriorate. The original email that was sent to the Prime Minister was forwarded to Mr. Blair's office, who then made no response whatsoever there. I also wrote to Mr. Blair's office myself asking for a response, and again, no response whatsoever there. I also wrote to Minister Haju's office there, and I did get a response from them when Dr. Nadeau wrote back to me and said that Canada has no compassionate exemption. At that point, you know, my wife deteriorated even further there, and ultimately she died unexpectedly. And that went from March to August.
Obviously, sir, very, very sorry for what you've been through and sorry to hear about your loss. Since this reintroduction of Bill C-20, have you been able to speak to the current Minister of Public Safety?
No.
Either one of you, sorry.
So the current Minister of Public Safety, Marco Mendocino, or Minister Blair, the previous, has not spoken to us. We've reached out many times.
Thank you. Chair, do I have much time left? I didn't start. Thank you. My next question will be for Ms. Anderson-Piers. I really hope I said that right. Recently, President Nathan Obed and Grand Chief Abraham Benedict testified at this committee and noted that the theory of police investigating police may lead to issues of a lack of confidence in the system. Do you agree with this assessment?
Yes, I do. I think it has to be completely independent, you know, because I myself, through the loss of my sister, experienced filing a complaint with the Public Complaints Commission, and I didn't find that it was independent. And, you know, it's difficult for individuals to investigate themselves. And when the letter was provided to my family that there was no negligence of duty related to the investigation into my sister's death, it was very, you know, it created further harm, and it was heartbreaking to our family to be able to, you know, read that an investigative body who is the RCMP investigated themselves, and we knew that right from the beginning that there was a negligence of duty into the investigation of how my sister died was very, it created further harm for my family to know that individuals are able to investigate themselves and report on the outcome.
Thank you.
Thank you, Mr. Shipley. We go now to Mr. Nur Mohammed. Mr. Nur Mohammed, go ahead, 6 minutes.
Thank you very much, Mr. Chair. And I want to start by thanking all the witnesses. And I want to start, Mr. McCall, by expressing on my part, and I think all of us here, our sincere regret for what you and your family went through. It's not okay. And we can't change that. We can't turn back the clock. But I did want to say I was really sorry to hear all of what has happened to you and your family. And hopefully through this process, we can make things better for others. I want to just start by digging in a little bit, Dr. Hassan, if we could, talking about the broader challenge that a number of families from Egypt have faced in Vancouver. You no doubt are familiar, you and Ms. Abdullah are no doubt familiar with these challenges. With CBSA guards who have been exercising a degree of authority of interpreting policies that perhaps may or may not have been in existence, and the consequence that this has created for a large number of these Egyptian families who have been deemed inadmissible with no ability for process of recourse, or in particular of anyone being able to look into this with obviously the lack of oversight. How would where we are today actually ensure that doesn't happen again? How do we make sure that in getting this bill right, that those types of challenges don't happen again?
Well, I think, thank you so much for that question. I think the reality is that there are many more, in addition to the families that you're referring to, that have had that experience. And sadly, the experience of crossing borders while Muslim is an experience that a lot of people are far too familiar with in the Muslim community. Globally and across Canada, it's unfortunate that it has now become sort of a recognizable phenomenon that people can actually characterize in particular ways. It includes things like people feeling like a lack of dignity, people feeling fear, anxiety, while coming to a place like Canada, which is supposed to be a multicultural society that is welcoming and kind of like a global guardian of human rights. So it is, you're absolutely right that this is a problem. And I think the fact that it is such a widespread problem, the fact that we see it as such a common experience amongst Muslim communities and others, it really points to the fact that there are systemic issues here that need to be addressed. And they need to be addressed appropriately. They need to be addressed with the proper resourcing, with the proper focus on organizational culture and problems that we see, like as my colleague Fatma referred to, in the types of references in the politics of citation that we see within the decisions that CBSA agents make. That is far too much power with very little integrity in the type of knowledge that's being used to make the kind of claims that they're making about these families. So I do think there's a systemic solution that's needed here.
So let's dig into that a little bit. I mean, look, with a name like mine, I can tell you that I have been through precisely what you've talked about. There are moments where you ask yourself, with a name like mine, with a faith like mine, why does that make it? Why should my experience be any different? I do think that there is a really important role for us to play in making sure that, and I've asked this in the past, I'm going to ask it to you, in making sure that we actually make this an experience, make the whole question of oversight something that is embraced by individuals on the front line, particularly at CBSA. So I'm really keen to do whatever we can to ensure that when this is implemented, it's implemented in such a way that it brings people along rather than drags them along. I think it's really important for us to do this in a way that allows people to feel like they are part of a solution. And so I would ask you, what are the things systemically that need to happen such that those individuals who are on the front lines at CBSA, and I want to be very clear, it's not everybody, right? It's not an everybody problem. These are issues in the system that we need to deal with. How do we make sure that those individuals have the training, the support, and the awareness that is required to ensure that they aren't going down this road of whether wittingly or unwittingly treating Muslims or others from racialized communities differently?
I think you're absolutely right. And I think there is, in an ideal world, we have everybody on board in terms of actually addressing systemic racism, addressing Islamophobia within our systems in clear and direct ways. But I do want to just put like a caveat to that I think the existence of this body is also meant to be something that ensures a level of fairness and equity and justice, regardless of whether people are coming along for the ride. So it is, I think, really important that we talk about those two things. But I think you're absolutely right. There is certainly, a systemic problem needs systemic solutions. So that means that everyone needs to be participating in kind of solving the problem.
So, Mr. Chair, how much time do I have left? I'm going to give those 18 seconds back. Thank you very much to all of you.
Thank you. Maintenant, c'est Madame Michaud.
I now turn to Madame Michaud. You have 6 minutes, please. Thank you, Chair, and thank you to the witnesses for being here today. Dr. Poon, it's great to see you again. We've met you sometimes virtually during the pandemic, so thank you very much for the work that you've done for all these people and for all of you members. Mr. Colm, I would like to offer my sincere condolences for everything that you've had to go through as well. Now, I imagine that most, or perhaps not the majority of your members, but in fact, could you give me specific examples where during the pandemic, if there had been a Public Complaints and Review Commission for the CBSA, do you think there's people who would have turned to this commission? Do you think there's people who would have lodged a complaint because they were not satisfied with the way that they've been treated by a CBSA officer? Can you cite some specific cases or examples that you have come across with your members who've shared their various situations? And could you talk about the usefulness of setting up this type of independent body? Thank you. I'm very sorry I don't speak French.
At the time acted as the intermediary where complaints are coming in. So when we had won our exemptions, very clearly publicly won our exemptions, it was on the website right next to the order of a council where extended family and compassion exemptions can come in. The day of, I wrote a letter for every single member, bring this with them because we don't trust the CBSA to believe you. And the fact is it didn't. They could look up who I was, they could look up our exemptions, but our members were told the day of, oh, no such exemption, you can't bring in your family, you guys are liars. If there was a sticker that said, hey, if you're being mistreated by the CBSA in both Anglais and en Francais, then they would be empowered to say, okay, buddy, give me your badge number, I'm going to go to this complaint office, they have a 2-week turnaround, and this is what we're going to do. So we, a group of nobodies, were hearing these complaints, doing the best we could. And thank goodness a number of agents did read the rules. But for those who didn't, for those who were outside the scope of where they should be practicing, that really harmed a number of people. Now add that to the fact that a CBSA agent can arbitrarily deny someone in the border for future as well. How scared are we? How terrified are we that we have to enter and risk never seeing our loved ones again? We need C20 to be effective. Merci.
Thank you very much. And you've brought out some publications on your Facebook page in favour of Bill C20. I don't know if you've gone through this bill. It's quite a voluminous one. But I haven't seen that many bills in my career. Perhaps there's other voluminous ones, but we've just gone through C21, and it was smaller, but there were more disputes. But it seems that everyone here, all the parties, agree upon the importance of setting up this type of body. But there's lots of details, and so perhaps there'll be lots of bureaucracy at the end of the day. So do you have any fears about the time limits for complainants? Do you have any fears about these time limits or delays? Do you think there's a way that it could be easier so that people get quicker answers? If you've got any comments on that, that would be very useful.
Thank my Director of Operations, Sean Dillon, who read through that big pile of papers to make sure we understood it well. In Section 1, there's a talk about joint timelines being created between the Commission and the CBSA and RCMP. The issue here is, if the timeline is made by both, that could mean that the CBSA and RCMP, who have historically done this, could delay and kick the can down the road. So, are we afraid? Absolutely. But we're thankful that hopefully the third time is the charm for this bill, that something's going to happen where it's clearly labeled for regular people to know what their rights are, know what they can do. And this, hopefully, creating the spotlight will no longer allow agents to work in the dark and do things that are inappropriate or worse, outright lies and misinformation. So that's our fear. I believe that SECU today can help put toward some hope.
Thank you. The committee has received several briefs from organizations who've made recommendations about various small changes that could be made to the bill. For example, people have said the fact that the chair of the commission cannot decide to undertake a complaint itself. It has to be the minister who asks them to do this, or the complaint decides to pursue the complaint once it's gone through the RCMP commission. So it's a bit of a different process. But I'd like to know if there's other changes like that you'd like to share. Of course, we're up against the clock. We're going to go into clause by clause. We're preparing amendments. So if there's changes that you think that would be necessary to make, I'd like to hear from you on that.
Essentially, I ask the legislators here to think, if John's family happened again, God forbid today, would the system have protected Donna McCall? And if the answer is no, then the bill is not strong enough. So, specifically, an urgent way, an escalation to a supervisor or someone who can make that decision, and an immediate turnaround if there's a discrepancy between what the CBS officer says and what the Order in Council says. If these things exist, that will bolster the citizen right and will allow stories like the McCall family to be prevented. He sacrificed so we can do better. I'm so grateful that you're taking the time to hear him out.
Merci, Madame.
Thank you, Madame.
Go now to Mr. Julian. Mr. Julian, please go ahead, 6 minutes.
Thank you very much, Mr. Chair, and thank you to our witnesses. I'm saddened by your remarks, and we just have to do better as a country. I wanted to start with you, Ms. Anderson-Pierce. You mentioned in your initial comments about the importance and the calls for justice for a robust, independent oversight body. Does C20 achieve that? And if not, what needs to change?
I think, I have to be honest, we were invited last minute as a witness, so we didn't necessarily have the time necessary to adequately review everything. But just from what we have reviewed, I think that there can be gaps, especially when you're looking at who will be represented and how will they be represented. And what does that independence look like? It's all really dependent on the different groups that you're speaking to. So I think it's critical to have diversity, at the table. And there also needs to be a gender balance, because when you look at policing, it was, raised that there was issues from coast to coast during the national inquiry into missing and murdered Indigenous women and girls and two-spirited and gender diverse people. And it also, that the system lacked accountability. So I would have to have a more in-depth review of the bill and any amendments related to the bill as well to be able to provide a fulsome response to that. But those are just some of my initial thoughts. So thank you for the opportunity to provide feedback.
Thank you, and so sorry, the tragic loss of your sister. And Mr. McCall, deepest condolences on the loss of your spouse. I mean, these are tragic stories, which underscores the importance of finally getting this done, but getting it done right. Now, we've had previous testimony, Mr. McCall, and I'll ask Mr. McCall and Dr. Poon. On the issue of management not making the right decisions. And I think both of your cases strike to poor management, poor integration of what should be clear direction, and the issue of resources. Are you concerned that C20 doesn't appropriately yet encompass the ability to tackle those systemic problems that are so important to resolve?
I'm concerned about the ability of C20 to address the urgent needs. I don't think that throwing it to committee, is going to help people who are urgently needing to get to the bedside of a dying family member. That wasn't my case, though. My case was not an urgent need. My case, went from March to August there. If anybody could have responded in a couple of months, it would have worked for my own case. But the C-20 address the urgent needs that are, days or hours or weeks? I don't think so. I think that we really need a process that not only supports the bigger pictures, but also the acute cases that need to be addressed more quickly.
We've been calling it Donna's rule. The idea that in any time, war, trade, COVID, another pandemic, there must be something within and entrenched within Canadian policy to never allow the separation of family like what happened with the McCalls. If we are willing to have that discussion, I'd love to have that. When it comes to C-20 specifically, the idea that there is evening of the power imbalance between the incoming traveler and immigrant and the CBSA agent, we believe that a strong, well-resourced, and truly transparent, that means stickers at each booth, truly transparent C-20 will give the strength to those coming in and allow that proper procedures will be followed. And this will help a lot of people if done properly.
Thank you. I'd like to turn to Dr. Hassan and Madame Abala. You raised a number of key points, one being to ensure that national security isn't a reason simply to not respond to the case, not to hear the complaint. Two questions, both, do you feel that the PCRC should have the same ability to tackle privileged information as NSERA does to really effectively do their job? And secondly, you've very eloquently spoken to attacking systemic racism, zero tolerance against racism and discrimination. Can you offer some direction, some successful pieces of legislation that have accomplished that, perhaps in other countries? Thank you.
Thank you so much for the question. In terms of your question around national security, the threshold that we are recommending is top secret clearance. Anything that is below that threshold should be within the purview of the PCRC. So that includes access to information that would be needed to do the job effectively. Again, our recommendations are based on the fact that NSERA is, as we all know, heavily overburdened in terms of the backlog and the caseload, but also the fact that it is not fair to make people wait that long for complaints that could be dealt with in a much more timely fashion and that could be resolved in a much shorter timeline. And the example I gave was of Mr. Almadi and his hearing aid, for example, which could be something that would be very easy to resolve through an effective institution like the PCRC that could handle a case that has some intersection with national security concerns.
Thank you, Mr. Julian. That finishes round one. We'll start round two with Mr. Lloyd. I believe this will have to be an abbreviated round to end following Mr. Julian once again. So, Mr. Lloyd, please go ahead, 5 minutes.
Thank you, Mr. Chair. And as others have said, my condolences for the loss that have been borne by all the witnesses here at the committee, and specifically for you, Mr. McCall. I mean, we've seen, especially during the pandemic, so many families quite unnecessarily separated, and it just really brings it home, the impacts that these have in cases such as yours. But to clarify, C-20, if it goes into place and this complaint mechanism is inputted, would that have changed your situation, you think? Because if the compassionate leave was not in place as a policy in the first place, you can make the complaints, but would it have led to a different outcome?
Possibly. It may have given us an opportunity to get a different answer. Keeping in mind, my children are the children of a Canadian-born citizen. Their right to Canadian citizenship is by birth, by descent. So if they had been able to present their birth certificate and their mother's passport at the border, if we had the opportunity to make that case, and we didn't have to wait on the IRCC to confer certification of citizenship on them, then I think, yes, it would have fixed this.
Thank you. And this is a question for you, but I'll pose it to the other witnesses as well. You know, we can set up this complaints mechanism, and it could work perfectly. It could work very well, but it's only as good as the people who need to use its knowledge and education about the intricacies. I imagine, you know, somebody who's not trained in government policies, or a refugee coming from abroad, you know, maybe they won't know, or they don't speak English or French as their first native tongue. How are they going to know to make a complaint? Do you, Mr. David, have any thoughts on you know, maybe ways we can amend the legislation to make, you know, an education aspect to ensure that underprivileged groups can know their rights?
And again, I thank my Director of Operations, Sean, for this. But Part 1, Section 9 speaks to education and information about the Commission. So it is my understanding that there already is a section to get the information out there. You're saying, how do we get to the disadvantaged groups? I'm saying very clearly, at Best Buy, if they charge you an extra $10, have a sticker. By law, we got to charge you less by $10, or you get it for free. We don't have that at the border for a complaints process where people's lives are being changed. So if at that section, in as many languages as possible, in whatever way we can do, operationalizing that sticker, that's already one huge part. The second bit is there'll be advocacy groups like us making sure that those with refugees, those recent immigrants, those with separated families hear it. If the government makes it very clear on a website, we will get it out there. But it must be clear, and the CBSA agents cannot say, oh, no such thing exists, you're banned for 10 years. That's the fear.
Dr. Hassan, are you satisfied with how the legislation lays out the education section, and what recommendations would you make if this is amended to, you know, serve your constituencies?
Yeah, no, I think for anything to be effective, that would need to be implemented with a lot of care, and I think my colleague here has kind of addressed the concerns that I would address the same way. Like, the more education we have, the more transparency there is about the process, the easier it is for, you know, your everyday Canadian to navigate.
Do you think there should be like a legal obligation for CBSA officers to make people aware of their rights to complain, or do you think that a sticker is kind of just that's good enough?
I mean, I think obfuscating the process is obviously not something in good faith, and like we've talked about before, there are systemic issues around the ways that we know a lot of Muslims at the border are treated, and that kind of, you know, sort of disparaging people for asking for recourse is something that is concerning, and we would want it to be addressed pretty directly.
And Madam Anderson-Pers, forgive me if I mispronounced that. Your thoughts on the same question?
I think, you know, we really have to focus on accessibility. You know, what is accessible, like, you know, to the average individual who may not have the privilege of being able to file formal complaints. As an example, you know, we have many Indigenous people in Canada who live in remote, isolated locations, you know, who have had traumatic experiences by police officers, you know, through police brutality and through systemic and structural racism. So we have to look at, you know, through a lens on how are we going to, you know, provide those opportunities for accessibility, and what does that look like? You know, it looks very different from someone, you know, sitting in a place of privilege compared to, you know, a lot of us in the general population who, you know, often fear systems and structures because of the, you know, the violence we have experienced through racism. So when I look at it, when I say accessibility, it has to be safe, you know, and it has to provide opportunities like, the one witness shared about the different languages, but also, there has to be funding made available to different organizations who can support, filing these complaints through independence, because it's often, as volunteers who try to champion change, many volunteers are doing this in addition to, carrying out their work-related responsibilities. So it's often on a volunteer basis. We need to ensure that there's, equitable funded mechanisms to be able to support individuals who want to share their story of injustice and to, have the appropriate action taken to create systems that are responsive and respectful as well. So thank you.
Thank you. Thank you, Mr. Lloyd. We'll go now to Mr. Chang. Mr. Chang, go ahead, please, 5 minutes.
Thank you, Chair. Thank you to the witnesses for being here with us today, and I will echo the same sentiment, Mr. McCall, about your family. My condolences to your family, and hopefully we can improve the system so that we don't have, no one else has to go through what you have gone through in your life. My question is directed to Ms. Hassan. I just want to expand on what Mr. Lloyd has asked you in regards to public education. If you can expand on that, how would you look at it in regards to how would you view it for different ethnic groups, for people of color or women? How would you look at public education? How can we improve on that, and what would you say we should do better?
I mean, I think at a minimum, not obfuscating the process and not denying people legitimate information is important. But I'm happy to kind of connect with either of your offices to send further information about what we think might be best practices around especially serving the Muslim community at the borders.
So much. You can send your information to the chair of the committee, and we will be happy to look at that. And my question is to, my apologies, Ms. Hilda. As someone who interacts with family members of Indigenous women who are missing or murdered, can you speak to the need for cultural competencies in the handling of complaints that may involve serious wrongdoings on the part of law enforcement?
Absolutely. I think it's, really critical that, there's representation there, someone who understands, the impacts of systems that have impacted us as Indigenous people. When we look at Indian Residential School, the 60 Scoop, the child welfare, MMIWG, 2S+, like we've been impacted by so many systems. So we have to ensure that we inform like a culturally appropriate lens, a trauma-informed approach, and that it's also, rooted in Indigenous ways of knowing, being, and doing. And when I say that, we have to ensure, like, the spaces feel safe to us as Indigenous people, and that the services that are provided are culturally appropriate as well. When I say that, we may have, ceremony attached to the individual who is filing the complaint, that we are adequately taking care of their well-being, their emotional, their spiritual well-being, as well as, creating that opportunity for healing as well, because it's very traumatic when you have, you think that you're seeking supports and resources that are safe for you, but to have a negative experience, really impacts your life and your trust of systems as well. So we have to, look at how do we build those, and they have to be independent of any, political structure or government structure, and like led by Indigenous people as well. So thank you.
Thank you so much, Ms. Hilda. I'm going back to Dr. Hassan there. Would you support a requirement that the annual PCRC report include a line on how many cases a year the Commission refers to in SARA, and from which agency the complaint originated from? Would you support it?
Yeah, I think that's a common sense thing to include in the report.
And do you feel like it should be an annual thing, or how far back should it go?
I can get back to you on that. I'll consult with our team, but I do think a routine establishment of that information would be important.
And is this something that, in your opinion, would need to be an amendment to the legislature, or something that could be worked out through regulation, or simply just a best practice?
Again, I can get back to your office on that. I'd be happy to connect.
Thank you so much for your time. And Mr. Chair, half a minute? Okay. If I can go back to Ms. Hilda, through C20, there are new reporting provision which requires the CBSA and the RCMP to update the minister and in turn the House of Commons and all Canadians on their efforts to implement the recommendation made by PCRC. Will this additional accountability mechanism be useful in holding the RCMP and CBSA accountable for the progress update they provide Canadians?
I think, to a certain degree, it will be helpful and it will be useful, but I really, stress the importance of having a completely independent mechanism, to be able to, hold agencies and institutions accountable and to take corrective action, and to implement mitigation strategies, to prevent the same occurrence from happening ever again.
Thank you, Mr. Chang. C'est maintenant Madame Michaud, encore.
And now Madame Michaud for 2.5 minutes. Thank you, Chair. Madame Anderson-Pierce, you represent, amongst others, women who have survived gender-based violence and race-based violence. And you represent various Indigenous communities, and as a result of their experiences, some people will hesitate to file a complaint. They're afraid that it might not actually give any results, or they don't want to relive a traumatic experience because perhaps they don't want to think about certain experiences and memories. So what about this idea of having a third party or organization such as yours to actually be able to lodge complaints on behalf of other persons, or perhaps not even on behalf of specific people, but be able to put in a complaint about an issue, a systemic issue that's been raised by women talking about their treatment by CBSA or RCMP officers? Do you agree with that proposal? It's something that we've heard from several organizations, and we're trying to see how we can include that in the bill. But I did hear some positive comments about allowing organizations to be able to do this type of work. Could I hear from you on that?
Yes, absolutely. I think it's critically important, to ensure that, like, we talk about accessibility, right? And we also, from an Indigenous lens, we understand that, as a victim of gender and race-based violence, we often have multiple layers of trauma, and it's very difficult for us to be able to file a complaint against systems, who have perpetuated the, systemic and race-based violence against us. So I fully support, having an organization support, filing complaints collectively or individually. I think this is an important step towards, ensuring that voices who are impacted have the opportunity to share their experience and, look for corrective action as well. So thank you.
Merci, Monsieur le Président. Thank you very much, Chair.
Merci. Mr. Julian, 2.5 minutes, please.
Thanks, Mr. Chair. Thank you to all of our witnesses. You've given us very valuable, wise counsel, and I know that we'll take this into consideration as we move to clause by clause in the coming days. Dr. Hassan, you didn't have a chance to respond to my question earlier about systemic racism, zero tolerance against racism and discrimination, how to integrate that into the bill. I also wanted to raise the concerns that we've had about lack of resources, indications that the federal government is financing perhaps about half the level that is really needed to adequately respond to to complaints both through the RCMP and CBSA. If you could take a moment now to answer those two questions, I'd appreciate it. Thank you.
Yeah, thank you. I'm sorry I missed answering that last question last time. In terms of the zero tolerance policies, we do recommend that it's a pretty basic idea that if a border service agent is found to be in violation of the CHRA, if there's discrimination that has taken place on the basis of protected grounds that are the rights that are protected in our Constitution, that person does not deserve the power that a border services agent has. So we do recommend disciplinary measures that are proportionate to the severity of that act. Secondly, I think in terms of national security, in terms of resourcing, one of our concerns around the PCRC is, of course, that for it to be effective, it needs to be functional, and it needs to be able to actually be resourced properly to meet not only the timelines, but also to take on the kinds of cases that we are hoping that the PCRC would be able to take on, including the national security cases that I was talking about earlier. So absolutely, I think resourcing is a key question here. And if it's not properly resourced, we're going to have the same problems that we have with other oversight bodies that become backlogged very quickly. And it's simply not fair to make people who are already in really vulnerable and precarious positions to suffer any longer just because of our lack of foresight in terms of the kind of resourcing required to really deal with a very big problem in Canada.
Thank you, Mr. Julian. So thank you all. That brings this panel to a close. We appreciate your time and your expertise. It will be most helpful to us in our study of this bill. We will now suspend briefly and bring in the next panel. Thank you very much. This meeting is resumed. We're once again resuming meeting number 72, I believe, on Bill C-20. We have today, as an individual, we have Dr. Christian Leuprecht, Professor, Royal Military College of Canada. We have by video conference the Independent Investigation Unit of Manitoba, Zane Tesler, Civilian Director by video conference, Roxanne Gagne, Incoming Civilian Director by video conference. And from the Saskatchewan Serious Incident Response Team, we have Greg Goudelot, Executive Director by video conference as well. So welcome everyone. I will let's start with Dr. Leuprecht. I invite you to make an opening statement of up to 5 minutes. Please go ahead, sir.
Merci de l'invitation.
Thank you very much for this invitation. I will make my comments in English, but I'd be happy to field any questions into official languages.
It's CBSA, the RCMP on accountability and governance within the intelligence community. I sit on a police services board. I lecture on police governance, so this is something that's dear to my heart. I believe that this is the third time this bill has been reintroduced. It's important that this bill pass, not just for the sake of accountability, but because there's growing awareness of inherent institutional bias and the importance of independent review bodies and publicly transparent follow-ons. The bill also offers an opportunity to remedy known shortcomings in the design of the current Civilian Review and Complaints Commission of the RCMP. The PCRC mirrors comparable changes in some provinces. In Ontario, Justice Tulloch's report of the Independent Police Oversight Review was the first and only independent systemic review in Canada of the police oversight system to tackle how complaints against police officers and discipline are handled. Justice Tulloch's report has 129 recommendations aimed at enhancing the public's trust in the system. In addition, Justice Murray Sinclair tabled a comprehensive report on the Thunder Bay Police. I commend both reports to this committee as they directly inform the committee's work on this bill. Justice Tulloch and Senator Sinclair pulled back the veil and exposed inherent bias in systems and organizations. Ontario recently established the new Inspector General of Policing as well as the Law Enforcement Complaints Agency. LECA was intended to mitigate biases and, in so doing, bolster public confidence in investigative processes. The rule of law is foundational to democracy. In line with the growing and evolving public expectations and scrutiny of law enforcement, the PCRC will provide an important mechanism to shore up public legitimacy by ensuring compliance and propriety among Canada's two largest law enforcement agencies, which together field about 26,000 uniformed members that are tasked with investigating many of the most important threats to Canada's national security and public safety. And while compliance and propriety are the sine qua non, independent review should also assess for proportionality, necessity, reasonableness, and efficacy. Specifically, I recommend, with regards to 28.8, that the legislation enshrine a 6-month limit for the RCMP or CBSA to provide written comment on the findings of a complaint or public interest investigations, unless there is genuine ongoing litigation or other court proceedings that such disclosure might compromise. Absent timely input from the RCMP or CBSA, the PCRC should have explicit authority in statute to release the public findings of an investigation. This is to avoid an agency needlessly delaying the public release of findings, as is currently the case with the RCMP, where public reporting has been shown that some CRCC reports have been languishing for up to 4 years. As I explained in my book, the actual concepts that inform a review should be written into the legislation, including but not necessarily limited to compliance, propriety, proportionality, necessity, reasonableness, and efficacy. The point of independent review is not just to ensure compliance. Rather, think of it as peer review that has as its objective to make the agency better at what it does. Instead of being reduced to mere discipline instrument, Complaints and review thus aim to become a process of continuous institutional improvement and transparency about those efforts as a key feature of democracy. 3, the public needs to have confidence that findings and recommendations are actually being implemented. As such, agencies should be required to report back annually on plans and progress in implementing PCRC findings and recommendations. 4, the bill currently lacks explicit wording to deconflict its mandate with that of the ERC as well as INSIRA and the NCI-COP. For public interest investigations only, the PCRC should be required to deconflict with these other mechanisms. Reviews are time-consuming and resource-intensive for agencies. As such, the RCMP and CBSA should not have to commit resources to answering the same queries from different agencies. Finally, 5, the RCMP and CBSA should receive financial compensation for the resources they need to expend on responding to PCRC complaints and reviews. Otherwise, additional onus of review comes at a net cost to operations for an agency. Je vous remercie. J'ai d'autres propositions.
Thank you. I've got other proposals, but we only have 5 minutes after all.
We're going now to the Independent Investigation Unit of Manitoba. Mr. Chesler, please go ahead. 5 minutes.
I'll be very brief. I am the civilian director of Manitoba's Independent Investigation Unit. I was the inaugural civilian director appointed in 2013. I'm now just a few weeks shy of my the end of my second term, or 10 years in this position. Our mandate in Manitoba is to investigate and involve ourselves, providing an independent overview and oversight of all serious incidents involving police within the province, including death, serious injuries, or breaches of criminal or statutory codes. In my time, in the last 8 years since we've been operational in June of 2015, we've now surpassed some 500 notifications for our unit to become involved in the serious incident investigation process. And I'm hopefully that my experience can assist in better understanding and developing the proposals under Bill C-20.
Thank you, sir. We'll go now to the Saskatchewan Serious Incident Response Team. Mr. Goodlow, please go ahead, please. 5 minutes.
Thank you. Thank you for to the committee for the opportunity to appear today. My name is Greg Goodlow. I'm appearing as the Civilian Executive Director of the Saskatchewan Public Complaints Commission and Serious Incident Response Team. My role today as a provincial agency head is not to advocate for a specific amendment to the federal legislation, but to provide what I hope is helpful information on Saskatchewan's police oversight regime, and hopefully to answer any questions the committee may have on the basis of my time spent in the justice system and my experience as senior positions at 2 police oversight organizations in 2 provinces. Saskatchewan's police oversight program is built around the Public Complaints Commission, or PCC. The PCC was created through amendments to the Saskatchewan Police Act in 2005 as the successor to the Office of the Police Complaints Investigator. The PCC is a 5-person non-police body appointed under the Police Act and responsible for ensuring that all parties, both the public and police, receive a fair and thorough investigation into the actions of police officers. The Act creates a number of requirements for the makeup of the 5-person board. At least 1 person must be a lawyer, 1 must be of First Nations ancestry, and 1 must be of Métis ancestry. In addition to these composition requirements, there are a number of mandatory consultations prior to the appointment to the board. These mandatory consultations include both representatives of police services and members, as well as Indigenous organizations. The PCC provides intake, oversight, and review functions to complaints relating to municipal police in Saskatchewan. Once a complaint has been received, the PCC can direct that the complaint be investigated by the originating police service. an external police service, or by the PCC itself through its investigation unit, the Public Complaints Investigation Branch, or PCIB. Importantly, Saskatchewan prioritizes not just the independent intake or review of complaints, but also the independent investigation of complaints, and ensures that the majority of complaints are actually investigated by the PCC itself and independently investigated by the PCIB, which maintains offices in Saskatoon and Regina. In addition to police complaints, the PCC's mandate has recently been expanding to include non-police law enforcement, primarily in the form of provincially appointed special constables. In 2021, the Saskatchewan legislature passed a series of amendments to the Police Act, creating the province's Serious Incident Response Team, or CERT. CERT is tasked with investigating incidents where someone may have been killed or seriously injured through the actions or omissions of police or while in the custody of police, as well as allegations of sexual assault or interpersonal violence involving police. Like the PCC, CERT's mandate includes not just police, but also certain other non-police law enforcement members appointed as special constables. Unlike the PCC, CERT's mandate includes not only municipal police, but RCMP members in Saskatchewan as well. The creation of CERT was unique in Canada as the first time that a serious incident investigation body was created under the same umbrella organization as the provincial police complaints body. Although PCIB and CERT are both parts of the PCC, they maintain operationally separate investigative teams and have different statutory decision makers under the Act, with the PCC chair being responsible for determining the outcome of complaints matters and the civilian executive director responsible for serious incident investigations. This arrangement has allowed for the appropriate separation required by the different evidentiary standards employed by each team, while realizing certain efficiencies through some shared administrative or management resources. The distinction between these two investigative units is important as it is based on the nature of the investigation conducted. While PCIB may conduct criminal code investigations following the receipt of a complaint, the body is primarily focused on disciplinary measures or disciplinary investigations under Saskatchewan's municipal police discipline regulations. CERT, on the other hand, conducts exclusively criminal code investigations into serious incidents and is notification-based rather than complaint-based. With this distinction in mind, I will pause to note that the proposed Section 14.3 of Bill C-20 seems to indicate that the CBSA itself would be responsible for conducting serious incident investigations. If the intent is for these investigations to be conducted by what I'll describe it primarily as a border enforcement agency rather than a full scope police service or an independent investigation body, this would be a non-standard approach, keeping in mind the expectation that these investigations be conducted to a criminal code standard. Overall, CERT's legislation seeks to assist with our mandate of maintaining public confidence in policing through measures designed to ensure both inclusivity and transparency. The legislation requires the appointment of a community liaison anytime the affected person on a serious incident investigation is of First Nations or Métis ancestry, and requires that the public be provided with a report on the investigation within 90 days of the investigation being concluded. Thank you. Those are my comments, and I'm happy to answer any questions the members may have.
Thank you. We'll start our round of questions now with Ms. Dancho. Ms. Dancho, please go ahead. 6 minutes.
Thank you, Mr. Chair, and thank you to the witnesses for being here and sharing your expertise. I do have a few opening questions for the two investigative units from Saskatchewan and Manitoba. We have there has been a bit of a recurring question theme as we've been going through the C-20 review process about the pros and cons of the current model that the RCMP uses with the Complaints Commission and perhaps to describe it as more independent models like your own that we see at the provincial level. And we are looking at whether C-20 is taking the right approach, and those discussions will continue as we move forward. So to Mr. Tesler, first we'll go, and then Mr. Goodlatte, if you can weigh in as well. Can you just, in short, provide some insight on perhaps the pros and perhaps also the cons of the way that your commission or your board is set up and the benefits of having sort of a more independent model?
Well, I think what's key at the outset is that we have a very defined mandate in that our primary purpose is to involve or investigate all serious incidents as defined in our legislation. All the provincial agencies have virtually identical types of mandates in that we are dealing with deaths, serious injuries as defined, or for most of the provinces, criminal code allegations against officers. As well, speaking for myself, and Greg can chime in when he's able, our legislation not only deals with the municipal police services created in the province of Manitoba, but we are also specifically mandated to deal with all involvements of the RCMP within the province of Manitoba. That in itself has required us to ensure that there is consistency in approach between the various provinces, given that most of us, particularly those in Western Canada, will be dealing with the RCMP, and there needs to be a standardized approach so that officers stationed in one province know what they are facing if they are transferred to another province for their service.
Thank you.
What's
perhaps,
key? Yeah.
Oh,
Yeah.
sorry. If you want, you can go right ahead and wrap up, and then we have about just a few minutes left for Mr. Goodlatte to weigh in as well. And again, I know we saw this with the Nova Scotia mass killing a few years ago. Their CERT was triggered, obviously, to review the ongoings there. But I suppose specifically, my question is: right now we have a bit of the RCMP, when the union rep came here, he did flag that there is some challenges with having the RCMP investigate itself regarding other complaints that don't involve the criminal code and issues that would go to you, and that officers investigating each other does not necessarily invoke public confidence. It also is not great for morale in a small office when officers are having to investigate each other for complaints. So just in that background, if you want to wrap up with a final comment, and then we'll go to Mr. Goodlatte to weigh in on that.
Yeah, actually, I'm going to defer to Mr. Goodlatte because his office will involve both the conduct and the serious incident involvements. In Manitoba, we've been very successful in providing the necessary independent oversight expected in the investigation of all serious incidents involving all police agencies within the province.
Thanks, Zane. I suppose in terms of the pros and cons or the issues with police investigating police, there'll always be an issue with the acceptance of that investigation, no matter how well it's done. So when the goal of these investigations and the goal of building an independent oversight unit is to enhance public confidence in policing and to give the public confidence that, you know, if a police officer is cleared following an incident, they were cleared following a fulsome investigation, or if charges result, the charges are prosecutable and again properly investigated. That can only come when the public fully trusts the investigative process. And the difficulty with the involvement of police officers, or one of the difficulties with the involvement of direct involvement of police officers in that process, is perhaps a diminished ability of the public to accept those the results of those investigations. But I think the issue that you referred to in terms of the morale issue is a real one as well. And that not every police officer signed up to investigate their colleagues, and I think there is a morale issue there, or there is at least a perception of the willingness to engage in that type of investigation. The advantage to independent investigative agencies, even when those agencies make use of seconded police resources, as some across Canada do, is that every member of that agency, every investigator at that agency, has made a conscious decision, or has made a decision to willingly be part of an investigative team that is primarily focused on the investigation of police-involved incidents. In terms of the other question and the sort of the pros and cons of the legislation or the makeup of my individual team, I think the pros from the legislation that we have, and I'm speaking specifically of the CERT legislation, there is a distinction between our complaints investigation body and our serious incident investigation body. But in terms specifically of the CERT legislation, I think the biggest pro for me, or the biggest advantage that we have baked into that legislation, is the flexibility in terms of engagement. So CERT has a number of options in terms of how it engages in a serious incident investigation. So once something has been deemed within mandate or within the scope of CERT's authority, we have a number of ways that we can engage on that investigation. The first is obviously to investigate that ourselves and to take the lead investigative role in that matter. We're also able to review those matters, oversee an investigation conducted by someone else, observe an investigation conducted by someone else, assist or conduct a collaborative investigation, or simply monitor it to ensure if further involvement is needed. That gives us the ability to match our resources and match the needs of an individual file to the capabilities of the team and to what's required to achieve public confidence in that particular case.
Thank you, sir.
I suppose the
I'm gonna have
con.
to cut you off there.
Oh, sure.
Thank you very much to both.
Thank you, Ms. Dancho. Mr. Moff, please go ahead. 6 minutes.
Thank you, Chair. Dr. Ruprecht, I'm going to start with you. First, to thank you for the input you provided this committee for many, many, many years on various pieces of legislation and on studies that we've done. And I know when you testified on systemic racism, some of the recommendations you made to us were around the CRCC at the time, but putting together this agency. So I just want to sincerely thank you for the input that you've provided and advice. I don't know if you were listening to the previous panel. One of the recommendations from NCCM was that the new commission also look at incidents that involve what would normally go to NCIRA. And I'm just wondering what your thoughts are, given your experience and research and expertise on this matter.
So my hunch is the way sort of the division of labor has been shaking out between NSICOP and NCIRA is that NCIRA does the more operational pieces and NSICOP does the broader strategic pieces. And here we have an opportunity, I think, with the PCRC to focus more on the tactical sort of items. And so I think NSICOP has, with 16 agencies plus and departments plus Department of National Defense, has plenty of work already. So I think we want to be careful, and we also want to make sure that people don't try to double or triple sort of dip in the system, so that we have a clear direction, what types of complaints go where, and that we have a mechanism if something ends up with NCIRA, that NCIRA has some direction as to what then gets pushed, for instance, to the PCRC to investigate. You probably have a broader and a much more diverse skill set within NCIRA than you might have in a CRCC. But I feel that the PCRC would have the opportunity to contract, either to coordinate with other departments for skill sets or to contract those skill sets themselves. So I'm not sure that NCIRA would necessarily be in a position to do better the work that is intended for the PCRC, but ultimately this is for the committee to deconflict. As you saw, I raised other deconfliction issues. So I think this is just a matter of providing clear direction, because it's resource intensive.
Another quick question for you. When Mel Kapp was here, he said that I think you have to keep the responsibility for doing these investigations on the agency. And that was, as you know, he did a lot of work prior to the legislation being brought in. And what are your thoughts? Because we have heard a lot about police investigating police. Should these investigations start within the agency before they go to the PCRC?
So the provincial agencies tend to have a streaming sort of mechanism as to what are conduct investigations that are done by the local forces and what are investigations that fall within the remit of the provincial agency. And so I think there's probably an opportunity here for perhaps lower level conduct investigations to be done within the agency. They might be more effective and efficient if it stays within the agency. At the same time, as you likely know, CBSA has been preparing for quite some time for the PCRC, not just in terms of its processes, but also in terms of the institutional culture. So I think there's not going to be significant pushback either way in terms of the decisions that you make. But I think here's an opportunity to get advice. I think what this does hint at is, and we got this with, I think, Ms. Dancho's question as well, one of the key issues is the transparency of what happens when agencies investigate themselves. I think it's not so much, I do think by and large these investigations are very well done, but there's very little transparency on what happens on the results of these, even for the complainant. So if it's done internally, there needs to be public transparency as to the outcome to legitimize the process.
Thank you. I'm going to turn to the Saskatchewan CERT. Very impressive what you're doing in Saskatchewan, I have to say. Very impressive. I want to keep on that same theme because you're serious incident response, right? How do you differentiate between, what we were talking about with conduct? One of the things we heard when the chair was here and others have testified about, most of these investigations get dealt with within the agency. So someone's had, I would classify them as more minor interactions. So when it gets to you, how do you differentiate between those that are not serious incidents that go to you?
So the key is, and I think Zane alluded to earlier, is a well-defined mandate. Death, serious injury, and serious injury being outlined in our regulations down to sort of specific injuries or specific bones that will qualify for inclusion under the term serious injury, as well as sexual assault, interpersonal violence, and then a somewhat seldom used catch-all for matters of significant public interest. That clearly outlines what falls within the CERT side. There will be some crossover between the two sides, and part of the trick of running an agency that covers both the complaints and the serious incident side is the appropriate separation and staging of those incidents. So on a certain matter that might also constitute a complaint or might also constitute something with some disciplinary jeopardy to a member, we have the option to park that complaint or park the consideration of disciplinary jeopardy until the conclusion of the serious incident investigation. At the conclusion of a serious incident investigation, our act allows me to either direct the matter over to the PCC side for further investigation if necessary, or direct it to the head of a police agency for the imposition of major or minor discipline if necessary. That approach allows us to appropriately stage the investigations, conclude the serious incident investigation, which is the criminal investigation first, before any consideration is necessary of the disciplinary side. There are also some companion protections for the members in there to allow the police officers involved the decision to participate in one of those investigations without necessarily providing a statement in the other investigation, because there are differences in terms of the compelled or voluntary statements that are required in each of those investigations.
Thank you. Thank you, Ms. Demoff. On y va maintenant, Madame Michaud. Madame Michaud.
And now, Madame Michaud. Please go ahead. You have 6 minutes. Thank you very much, Chair, and thank you to the witnesses for being here. And I'm going to turn to Mr. Leprecht. You didn't have enough time in your opening remarks. You had other proposals to make on Bill C-20. You are looking at this favourably, and you've talked a great deal about accountability and the importance for this type of commission being independent so it can do the work that we're asking it to do. So I'd like to hear more from you on the proposals that you'd like to make to us. I was saying to another witness that we're always up against the clock, and we're trying to draft our amendments, and we've got clause by clause coming up next week. So if you've got proposals to share with us to improve this bill as much as possible, then of course we'd be happy to hear from you. Thank you very much for giving me that possibility. There are consequences when it comes to the disciplinary measures in the bill for the agency and also for the RCMP. So the disciplinary measures for the members of the RCMP, which are currently in the bill, I think are not severe enough. Even the most stringent ones are not stringent enough. So I think that one of the frustrations from the general public might be that you're going to have very good investigations, but public will be frustrated when it comes to the disciplinary measures for some of the members involved. Because we know that the investigations from the Civilian Review and Complaints Commission have got certain members that have been investigated on several occasions already. So perhaps we need to review that issue. And then secondly, during the investigations, the members continue to receive their salary in Ontario and in other jurisdictions. They have set up certain measures whereby a member will no longer receive their salary. So it's not very disciplinary for a member who's faced with a possible criminal investigation if they continue to draw their salary for years. So I propose there should be a measure whereby if someone is convicted, we can actually get back the salary that was sometimes paid for years to this individual. Often these individuals also can draw a pension. So I think that there's measures that need to be taken there. Then a third point, and sorry to switch to English,
of special constables, which is currently a debate in Ontario as to whether special constables do or not fall under the regime and under what measures within that regime. And so I think that is also something that perhaps might need to be clarified either in law or in regulation.
So when talking about special constables, are you talking about the RCMP reserves who wouldn't actually be covered by this bill? Yes, exactly. Everyone who wears a uniform and who is not a regular member of the RCMP or who's not a member of the CBSA agency. Yes, thank you. That's a comment that has come up. There was a representative from an Indigenous community who said that in our community we just basically have reserve personnel. So if they're not held accountable, then public kind of lose their trust in the system if they can't lodge a complaint against reserve agents. So we do understand that it's important to do something on that issue. Now, in the brief from the Canadian Bar Association, the CBA, well, you referred to national security with Ms. Damoff, and the CBA pointed out to us that sometimes there are specific points in French, and I'd invite the analysts and the legal clerks what they think about this. But sometimes we talk about activities that are linked to national security, and sometimes we talk about activities that are closely linked to national security. So it seems that these are two different things in French, and some groups have said that perhaps we need to define exactly what we mean when we refer to national security and what that actually would include within this bill. So I don't know if you have a specific opinion on this. I know it's quite a technical point in the bill, but when we're talking about something like national security, we have to know exactly what we're talking about and understand all of the ins and outs, don't we? So on the special constables, first of all, So the RCMP is overrepresented in small communities where members of minority communities are underrepresented. So that really is a very important issue at stake when it comes to this bill. And turning now to national security, we've got this distinction. We've got these mandates for the RCMP, federal policing and national policing. So they've got a federal or national mandate on the one hand, and then there are these RCMP contracts. So the distinction is the type of activities that are being carried out by the police service in question. Thank you very much, Chair.
Yeah. We'll go to Mr. Julian, please. 6 minutes, but everyone else has got almost 7, so except for Christina. So maybe take 6.5, and it'll probably stretch to 7. So go ahead, please.
Merci beaucoup, Monsieur le Président.
Thank you very much, Chair, and thank you very much to witnesses today. Now, Mr. Lebrecht, I'd like to come back to the comments that you've just made. In responding to Ms. Michaud's question, you mentioned something that's important here. You've said public can be frustrated about consequences if consequences after a justified complaint are quite limited. And you've talked about a possibility of an official being paid even if they have not been in compliance, and you've talked about clawing back their salary. Do you have examples in other countries where public complaints bodies have done this sort of thing? Have they asked for a financial penalty being imposed upon a security agent or this type of public security official who has not followed the rules and adhered to the values of his position? The only place I know of that's done this is in Ontario, and in Ontario there's been a debate about this. There have been many lengthy discussions about the conditions whereby this could actually be applied. Can there be a suspension without a salary from the outset? As soon as a certain threshold has been met? Or is it a question of the taxpayer being able to claw back the salary amounts that were paid for a certain amount of time? We have to realize that these disciplinary procedures can stretch on for years, for many years. So it seems to me that there's no incentive for people to behave better if they know that even if they've seriously behaved badly, they're nevertheless going to continue to receive their salary for years to come. It is a tough debate, but given the current situation and the current RCMP Act, well, all this does not boost the public's confidence in all this. Sorry, but I have other questions now as well.
One of the issues and concerns that have been raised is the lack of resources that is actually budgeted for this new complaints commission, given the rise in the number of complaints. It is very clear from the testimony we've had that the funding is wholly inadequate. So I'm interested in the funding that exists in Manitoba. You mentioned 500 notifications. Now, those are not complaints from the public. These are notifications coming through local police authorities?
That is correct.
Okay. And that's over a 10-year period?
8 years.
8 years. Now, so the public cannot raise complaints that go to the Independent Investigation Unit?
That is correct.
Okay. So with those 500 notifications, would it be fair to say you've had 500 investigations?
We're probably in excess of 400 investigations. As Greg mentioned during his discussions, Manitoba, like Saskatchewan operation, also has the ability to monitor investigations. We have the ability to be the direct lead investigation body in the majority of cases, but on the discretionary matters or things less than serious injuries, less than or certain types of criminal code or other statutory violations, we may assume a monitor role to provide that degree of oversight as well. So I would say about 80% of our notifications do result in investigations led by our unit.
So my next question is, what is your overall budget? How many investigators do you have? And are they permanent or are they seconded to you?
Currently, all of our investigative staff are full-time employees of the IIU. We have 8 senior investigators, 2 team commanders or supervisors, and a director of investigations who oversees that end of the operations. In the end, all of the investigators are under my sole and direct supervision.
And what is your budget?
Our budget is $2.8 million currently.
Gosh, okay. And really, in terms of notifications over 8 years, you're talking about 50 investigations a year on average with a $2.8 million budget.
Yes.
And we are talking about potentially up to 10,000 investigations through CBSA and RCMP with a $19 million budget. I mean, I just don't see that budget having any relationship with reality.
I have to say, for any operation that is to provide an independent oversight role, has to be properly funded, properly resourced. It is so easy to have your resources outstripped by the matters that come before it. We have no control as to when we're going to deploy or become involved in an investigation. It happens when it happens. Our team has to respond immediately, regardless where in the province of Manitoba the event occurs, and we have to be there with the same degree of dispatch as we would in downtown Winnipeg. But it's so easy to lose your resources if you don't have sufficient ability to maintain them.
Yes. So I'm just doing a quick calculation. The Federal Complaints Commission would have about 6 times your budget, but about 200 times the volume of complaints. Does that sound realistic to you at all?
Not in the least.
Yeah, this is a major problem. If the chair is a little flexible, I'd like to ask the same question for our Saskatchewan guest.
Go ahead. Everyone else got almost 7 minutes, so go ahead.
Thank you very much.
The only distinction I'd make when answering that question, though, is we can't equate a complaints investigation with a serious incident investigation. A serious incident investigation is, in cases that result in a death, a homicide investigation. It's conducted in accordance with the principles of major case management. It is conducted by major crimes investigators or independent investigators operating with very much the same skill set as major crimes investigators. And that's not to diminish what a complaints investigation is, but a complaints investigation is approached and resourced differently. So to take that 10,000 number and say, that equates to 10,000 serious incident investigation, I think that's probably not an accurate comparison. But in terms of the overall point or the overall principle, effective civilian oversight does need to be appropriately resourced. And whatever that number happens to be, depending on what the individual requirements of those 10,000 files are or those 50 files are, you have to be able to meet the public expectation. And even with flexibility built into our act in terms of how we respond on the serious incident side or how Zane can monitor on his IIU program, even with flexibility built in. I think one of the observations that you'll see as you grow a civilian oversight program over time is that expectations start to run towards the top of that engagement list. So even though you have the ability to observe a police services own investigation or review a police services investigation, when you build a civilian oversight unit, the expectations of the public rapidly become that your unit will conduct that investigation and it will be an independent investigation rather than one that's simply monitored or reviewed. So building in an engagement list like that can help mitigate some of those resource concerns. But at the end of the day, the public expectation and the need to develop and build public confidence is always going to require you pushing towards the top of that list. So, I guess, will I say there's ever enough resources? Well, there's never enough resources. You can always do more. You can always take more files and raise them up in that engagement list. But it is a zero-sum game, and it's a pool where you're playing with finite resources and significant demands in terms of the public expectations.
Thank you. I think we need to cut it off right there. So we have very little time left. I'm wondering if the committee is interested in a lightning round of 2 minutes per party. No? We're not seeing a lot of interest in that. Okay. Yeah.
I'm fine to try.
So let's try that with starting with Mr. Motz, and Mr. Motz has to leave as soon as he asks his question. So I've undertaken that we won't do any substantive votes once he's gone, although that's a good opportunity.
Before I start, I want to see Talib unravel his rat's nest over there. Oh, you did. Look at you go.
Okay.
Okay, thank
2
you,
minutes,
Chair.
please, sir.
And thank you, gentlemen, for all three of you for being here. And Mr. Julian took a lot of the line of questioning I wanted. Great testimony. I really appreciate it. So I guess for me to sum, we all know, we'd be naive to believe that a PCRC is going to investigate every complaint that came in to them about either the CBSA or the RCMP. We know that. And so, it would be reasonable to also suggest that those minor complaints, a threshold would have to be determined what a minor complaint is and what gets passed on will be investigated by the agency. So my concern is that has been mentioned, and I've asked several witnesses this over several panels, the funding. It's not enough, it's not enough, it's not enough. So the PCRC is set up now to deal with the RCMP, a modified version of what they have currently, but now we've added the CBSA. So, Dr. Leuprecht, do you think that we're actually going to be able to make things work as indicated in the legislation by adding the CBSA? You talked about organizational change already occurring. Is that enough with the expectations the public has and the right balance we have to strike?
So I think it would be a mistake to think about this as additive, right? So the interactions that CBSA has with the public are qualitatively different, are quantitatively different from that of the RCMP, and the CBSA has a very different training regimen. It is, I would say, much more robust than what the RCMP does at Depot. So I think and even if there's, in most cases, when there's an arrest, for instance, to be carried out, CBSA will call in the RCMP to carry out that arrest. CBSA will usually only engage in the detention piece. So I think you won't see the types of extremely resource-intensive and onerous investigations that you might see with the RCMP.
Just one last quick question, if I may. I'm familiar with ACERT in Alberta, SCERT and MIIU in Manitoba, and Dr. Leuprecht. Do you think this act clearly defines the threshold we require to determine when PCRC is going to begin or get involved and when the agency should? And the final statement is just that transparency in investigations is key, and I think that will solve a lot of problems.
Very quickly, if you can, sir.
I'll need to think about that to give you a written response. But, I mean, the distinction is important, and then, of course, to avoid any asymmetry across the country in the treatment of sworn members is also critical, so that we have one systematic process and a proper triage. But lots of provinces do the triaging, so this is not rocket science. We can figure this out.
Thank you much. Mr. Gahir, please, 2 minutes.
Great, thank you, Chair, and thank you to the witnesses for their testimony. My question's for Dr. Luprecht. I think you've touched on this already, but I wanted to give you more time to clarify. One of the issues that we've looked at during the study on Bill C-20 is the interplay of the PCRC and other provincial police review and oversight agencies. Can you talk about the interplay between these two different jurisdictional reviews and oversight bodies and how they can actually work together to ensure more police accountability?
So it's a super question. It's probably a question that requires resolution more in regulation and in policy than in legislation. But the issue the public is going to have, right, they don't know what all these different agencies are. They don't know they can make a complaint to the local police service. There's a provincial agency. There's the PCRC. So what we need is a proper mechanism to make sure that wherever the public shows up, it's not like the healthcare system where we send you to 15 different physicians to try to figure out what's going on. If you show up with your local service and you want to lodge a complaint, you're going to get the same answer as you would get to go to the provincial agency, the same answer you would get from the PCRC, and that we don't have the local agency tell them, well, sorry, we're not responsible. You're going to have to go to these folks in Ottawa and whatnot. So that would be the one concern that I have. And the other concern that I have is, of course, anything that gets pushed down from the PCRC to other entities. We need to make sure absolutely that there is a uniform regime across the country for sworn RCMP members and anybody who is seconded to the RCMP, because the last thing we want is obviously different treatment in different provinces according to different types of standards and so forth. So how we work out the asymmetries in a country with 8 different contract policing, plus territorial policing, plus indigenous policing, and then national and federal policing. So there is a bit of the devil in the detail to make sure this is done systematically. But I'm sure the RCMP Association will be delighted to help in making sure that there is equity in the treatment of members.
Thank you, Mr. Gahir.
Thank you.
C'est maintenant Madame Michaud, 2 minutes.
And now Madame Michaud for 2 minutes. Thank you very much. Chair, to round off, Mr. Luprecht, I'd like to come back to what certain witnesses have told us. Namely, often associations of lawyers who represent immigrants or refugees have said that a CBSA agent has a lot of power, and that's quite a specific situation. A police officer or a CBSA agent has power, but they've had training, but perhaps more training on the RCMP side than on the CBSA side, and sometimes we've seen an abuse of power of this type. So do you think that today or the day when the commission is set up to receive these complaints about the CBSA, do you think there will be an explosion of complaints from people who've suffered abuse? What's your view on that? And in particular, this question of power or this perceived power that's held by certain CBSA agents. I'd like to hear from you on that. I think you'd like to have 2 types of specific complaints. One that would be related to CBSA detention, and the other one would be at land borders. Because at the marine border, there's not much interaction. And when you arrive by plane, if you're not Canadian or American, you have to fill out the Advanced Travel Authorization, the ETA. So there's less of a chance that something will happen. But the extraordinary powers of the CBSA, yes, but these are powers that are comparable with most of our democratic partners, because entering into a country is a right, it's a privilege, in fact, and the interactions with the police within the country flow from the fact that you've already been granted the right to come into the country. So I think it's a different type of interaction that we're talking about. and perhaps we could accelerate certain treatment of certain complaints from the CBSA when we talk about very severe personal consequences. If someone is refused entry, as we heard about in the last panel, but if your phone is confiscated and you think that's unjustified, then well, perhaps there you've got to wait until the CBSA gives you your phone back, and if it takes several months, well, too bad. Thank you very much, Madam.
Take us home. 2 minutes, please.
Thank you very much, Mr. Chair, and you were very generous in my last round. So I won't abuse it this round. I'll come back.
I fell asleep.
To Dr.
It's my fault.
Well, thank you. No, it was 10 minutes. It was awesome. So, Dr. Leprec, we've just been speaking about the resource issue. You mentioned it in your opening statement as well, the importance of having public confidence. And yet there seems to be a clear gap between what is required to effectively do the job for this new complaints commission and the actual funding required. And we've actually heard testimony that the funding that was requested was far higher than what's actually being provided. How important is it that this be adequately resourced, and what are the consequences if it's not adequately resourced?
So look, as you know, at RMC, I'm not just a prof. I'm also happen to be a civil servant. For the tasks that I currently have for national defense, I have a small budget. I have a small staff. And, you know, when you want to change your staff, you want to change your budget, there's a proper business process, there's a proper business plan. And so my suggestion would be just make sure that the new PCRC has a proper business planner and that they know how the business and financial and staffing processes in the federal government work. This is not obvious. It is a bit of a mystery how you make them work, but there are people who can make them work despite all the rules we have in place. And so I think this is not a prohibitive issue. I think with proper business planning, this is readily resolvable should the PCRC find itself in a situation where it either does not have sufficient positions, sufficient budget, or is not able to match positions and budget.
But we know from the get-go that it's under-resourced. So what are the consequences in terms of public confidence if the process is so slow that it simply doesn't provide the response that the public would want to see?
Well, the more resources you provide, the more strain you're also going to provide on the agencies, right? So there's because the more inquiries you're going to get, and I think ultimately this is for the government of the day to figure out, and we probably need to have a proper assessment process. One of the things that's missing in this country is regular reviews, for instance, of legislation such as this. Maybe the committee can propose that within a certain number of years we can review the legislation, and at this point there's an opportunity to voice concerns about the functioning of the legislation, the budgetary situation, the staffing situation, and the like. I probably would suggest we don't get this legislation is too important to be held up on whether we have exactly the right amount of staffing or the right amount of dollars allocated or not.
Thank you, Mr. Julian. And thank you to all of our witnesses. You've given us a great deal to think about and been most helpful for our study. Thank you to the committee for putting up with the erratic timekeeping of your chair. And with that, we are adjourned.
you.